We will punish the judges. That single line, delivered not by a rogue state but by the United States government, has just exploded onto the world stage, and it's already dividing diplomats, lawyers, and everyday citizens. But here's where it gets controversial. The judges in question don't work for any domestic court. They sit on the International Criminal Court, the very body meant to hold war crime suspects accountable when national courts cannot or will not act. Moments ago, the U.S. State Department unveiled a fresh wave of sanctions aimed at 4 senior ICC officials. The list reads like a mini United Nations roll call. Judge Kimberly Prost from Canada, Judge Nicolas Yen-Guillot from France, Deputy Prosecutor Najat Shamim Khan from Fiji, and Deputy Prosecutor Maim Mandie Niang from Senegal. Each now faces frozen American bank accounts, a travel lockout, and a sweeping ban on any business dealings with U.S. citizens or companies. Why them, and why now? According to Secretary of State Marco Rubio, these 4 foreign persons crossed a red line by using their ICC positions to investigate, arrest, or prosecute U.S. or Israeli nationals without the consent of Washington or Jerusalem. In plain English, the U.S. argues that because neither America nor Israel has ever joined the ICC treaty system, the court has no legal right to touch their citizens, no matter what evidence may exist. Let's break it down for anyone new to the debate. Judge Prost reportedly signed off on reopening a long-dormant ICC probe into alleged U.S. torture and detainee abuse in Afghanistan. Judge Guillot is said to have approved the ICC's headline-grabbing arrest warrants for Israeli Prime Minister Benjamin Netanyahu and former Defense Minister Yoav Gallant over actions in Gaza. Deputy prosecutors Khan and Niang, who took leadership roles in the ICC prosecutor's office in May, are accused of continuing to support those same warrants and any future steps against Israel. Rubio's verdict was blunt. The ICC keeps ignoring national sovereignty and weaponizing lawfare against Americans and Israelis. Translation: Washington sees the court not as impartial justice, but as a political cudgel. And this is the part most people miss. The sanctions don't just slap the 4 individuals on a list. They freeze every dollar these judges and prosecutors might hold in U.S. banks, bar them from any transaction routed through the American financial system, and extend the same penalties to any company in which they own 50% or more. Even indirect workarounds, think shell companies where third-party payments are explicitly covered. In short, the U.S. Treasury just built a financial moat around them. The ICC, headquartered in The Hague, fired back within hours. In a rare public broadside, the court called the new sanctions a flagrant attack on judicial independence and an affront to the rules-based international order. It reminded the world that 125 countries, ranging from Canada to Ghana to Germany, have signed on to its founding treaty and therefore recognize its authority. The statement closed with a pointed appeal. Remember the millions of innocent victims who rely on the ICC when national courts fail. So who's right? That depends on which lens you use. Supporters of the sanctions argue that no international body should be able to haul American or Israeli soldiers, spies, or leaders into court without those nations' explicit consent. Critics counter that powerful countries can't claim immunity forever, especially when allegations involve torture, indiscriminate bombing, or forced displacement. The legal backdrop is just as tangled. President Trump signed the original executive order in February, declaring the ICC's actions illegitimate and baseless. The order laid out a menu of possible penalties, asset freezes, visa bans, and more, that the State Department is now serving up in full. Yet the U.S. itself helped fund the ICC's early investigations in the 1990s and still cooperates on certain cases. That contradiction fuels the controversy. Is Washington defending sovereignty or simply shielding allies and itself from scrutiny? One thing is certain: the ripple effects are real. Human rights NGOs worry that other authoritarian governments will mimic the U.S. playbook, slapping sanctions on judges whenever war crime probes get too close. Meanwhile, European diplomats are scrambling to shield the 4 officials from secondary sanctions, quietly asking banks and airlines to keep services flowing. So here's the question that could light up the comment section. Should any country, no matter how powerful, be allowed to veto an international investigation into its own citizens? Or does true global justice require that even the strongest nations face the same courtroom as the weakest? Drop your take below. Do these sanctions protect sovereignty, or do they sabotage the very idea of universal accountability?